Thank you, Anna. Thank you, Jarek, and for inviting me. Thanks to Vlad and Peterson Peters for hosting this event. After that flattering introduction, I feel it will probably be a bit of a letdown. I'm not quite sure why I've been invited, apart from the fact I'm an international lawyer who moonlights as a criminal lawyer occasionally. So perhaps like Anna a bit, I've got my feet in both fields. But what I want to do in this lecture, it's already been alluded to, is to examine how arbitral proceedings and domestic criminal processes can interact. So to begin with some fairly rudimentary definitions. First of all, during my talk, I'm going to give examples from both commercial and investment arbitration. By commercial arbitration, obviously, I mean proceedings based on an arbitration clause in a contract between the disputing parties. By investment treaty arbitration, I refer to cases where there may not be any contract between the disputants. The arbitration proceeds on the basis of a commitment made in a treaty by the respondent state to arbitrate disputes with a certain class of foreign investors, which the applicant claims to be a member. Although respondents in investment treaty arbitrations are almost always states, states and state-owned enterprises can also be parties to commercial arbitrations, and that has some relevance to our subject today. Second, when I talk about criminal processes, I'm referring to all procedures for the investigation and prosecution of suspected criminal behavior up to acquittal or conviction. So my focus is not only on the outcome of such proceedings. What I want to do is talk about three contexts where arbitration and criminal proceedings can interact. There are others. The first is where, and this has already been alluded to, where conduct which is the subject or a subject of arbitral proceedings is also the subject of criminal proceedings. The obvious example is in the context of bribery. In arbitration proceedings, it's alleged that the contract is void or voidable because corruptly procured, while at the same time the individuals, or indeed the corporate entity, said to have colluded in the corrupt transaction, pursued for the crime of bribery. The second context is where conduct undertaken in the context of the arbitral proceedings is alleged to be illegal and subject to criminal sanction. So an example here would be when the way in which evidence presented by one party to the arbitration was allegedly obtained results in criminal proceedings being instituted against those responsible for its collection. And the third is when it's alleged that a state party to an arbitration uses its control over its investigatory, prosecutorial, and judicial authorities to seek to prevent the other party from effectively pursuing the arbitration. To take an extreme example, by imprisoning its key officers or witnesses. Now, such conduct has been alleged in a number of recent investor-state disputes, including a number where the respondent states are European, even an EU member state. Happens all over the place. Now, you'll have already seen there can be an overlap between these three contexts. What a state party to an arbitration claims and an appropriate response by its law enforcement authorities to cogent allegations of criminality can be claimed by the other parties to be persecution directed to preventing it from prosecuting its case before the arbitral tribunal. I'll look through all three of these. So I'll start off with allegations of corruption, probably the least on that. Now, so first question is, what should an arbitrator or an arbitral tribunal do when faced with the situation that one or both of the parties to the arbitration is facing criminal proceedings in relation to conduct which is also at issue in the arbitration? Now, I use the term corruption fairly widely. To be honest, it's easier now because we actually have some consensus what corruption might be, but I include bribery of both public and private employees, facilitation payments, that is payments made to public officials to do what they're anyway required to do, was also included, although some countries' authorities traditionally have not viewed such payments as illegal when paid by their nationals to do business abroad. And I'll also say a little about intermediary agreements, because some countries traditionally have banned or at least restricted the use of intermediaries in public procurement, and also because the exercise of personal influence on governmental officials, which is what some of such agreements contemplate, is generally considered to be corrupt, apart from in the UK, obviously, where it's perfectly all right. Special channel for COVID procurement, for example. Here, of course, the transnational nature of arbitration can complicate matters. And I'll just take a fairly recent, it's a 2020 decision of the English High Court in a case where enforcement of an award was resisted on the basis that it would be contrary to public policy. Now, in that case, the defendants were companies registered in France and England. They wholly owned subsidiaries of the Alstom Group. The claimant, ABL, was a Hong Kong company which had entered into intermediate agreements with the Alstom companies to assist in their tenders for projects run by the Chinese Ministry of Railways, which I don't think has had a particularly illustrious history in recent years. Now, each of the agreements was governed by Swiss law and contained an arbitration clause providing for disputes to be referred to ICC arbitration in Switzerland. Alstom failed to pay several of ABL's invoices. ABL brought arbitration proceedings, and the backdrop of this refusal, according to Alstom, was criminal proceedings in the UK and the United States against the Alstom Group, which had led to a new focus on the group's compliance obligations. They said, can't pay these because of our internal rules, essentially. Now, nonetheless, having found that the indicia put forward by Alstom were insufficient to prove corruption by ABL, the tribunal awarded damages against Alstom. An attempt by Alstom to set the award aside in the Swiss courts was unsuccessful, but Alstom was, at least initially, able to resist enforcement in France. I won't go through what happens in France, but it goes all the way up to the Cour de Cassation and back again, and it takes quite a number of years before the French courts are willing to say that the award can be recognised and enforced. By contrast, the English High Court, first instance court, allows arbitration. Now, allows enforcement. So why is it important? Well, here we have a situation where the parties are different nationalities. The law chosen by them as governing their contractual relations differs from the law of the place of performance of the contract. Criminal proceedings are brought against one party to the dispute by two sets of national authorities, in the US case, at least on a long-arm basis. Interestingly, in its answer to the request for arbitration, Alstom requests a stay of proceedings pending completion of the criminal investigations, albeit it subsequently withdrew the request. So the first thing is, should an arbitral tribunal, we've already heard about Fiona Trust. I'm not going to say anything about Fiona Trust and Privalov. Should an arbitral tribunal stay proceedings until criminal proceedings are complete? Now, such a course might seem initially attractive, not least because national authorities, with their greater subpoena and enforcement powers to compel the production of evidence, might be thought better placed to get to the bottom of such allegations than the tribunal. On consideration, though, a stay rarely seems appropriate. Firstly, it would mean the tribunal would not act for an indefinite period. Indeed, quite when criminal proceedings end might not be obviously apparent. National authorities do not always state they've definitely concluded their investigations, reserving the right in particular to reopen them should new evidence emerge. Paradoxically, it might assist the respondent party, were there to be a stay, as during that time it would avoid having to address the alleged contractual consequences of his actions before the arbitral tribunal. And thirdly, of course, the obverse of that is a stay might disadvantage the applicant, as developments might make it less likely that it could recover from the respondent, the latter's insolvency to take one example. So, and indeed the ABL Alstom case also demonstrates other reasons. First, the applicable law can be different. In ABL Alstom, the law of the contract was Swiss law, as was the law of the seat of arbitration. The law of the place of performance of the contract was Chinese law, although its potential applicability doesn't appear to have been an issue in the arbitration. As I said, criminal proceedings brought by the UK Serious Fraud Office and the UK Department of Justice and prosecuted under English and US federal law, respectively. Had those proceedings determined that Alstom had acted corruptly in its activities in China, which neither of them did, the tribunal would still have had to have determined the legal consequences under Swiss law of such determinations. Now, of course, this issue has arisen in particular in regards to intermediary agreements. In the famous Hill-Martin case, quite old case now, but old ones are good ones, the first arbitral tribunal held an intermediary contract null and void under its Swiss governing law. Such contracts were illegal under Algerian law, which was the law of the place of performance, and contravention of this prohibition, which was aimed at fighting corruption, breached the Swiss conception of good morals. The Swiss Federal Tribunal, however, set aside the award on the grounds that the Algerian prohibition was too broad and that Swiss law regarded intermediary agreements as lawful if entered into for non-corrupt purposes. And a new tribunal held the agreement valid and ordered OTV to pay the outstanding balance of Hill-Martin's commission. Further problem arises. In Hill-Martin, Algerian law was the law of the place of performance and thus arguably applicable as overriding mandatory provisions of the law of the country where the obligations arising out of the contract have to be or have been performed, to use the language of Article 9.3 of the Row 1 regulation. Now, in ABL and Alstom, neither the parties' chosen law, nor the law of the forum, nor the law of the place of contractual performance governed the criminal proceedings against Alstom. Secondly, another reason, more fundamentally, although the burden of proof remains on those alleging corruption, the standard of proof for allegations of corruption differs in civil and criminal procedures. Now, the standard of proof in criminal cases, and I'm speaking as a common lawyer here, of course, is beyond a reasonable doubt. Although we don't like to say that nowadays, we talk about you have to be sure. In civil cases, it's the balance of probabilities. There's a line of arbitral decisions that talk about, you've got to, it's got to be particular, you've got to have clear and convincing evidence. But in reality, I think that simply is saying, as the Supreme Court said in Re B, that the more serious an allegation is, the more cogent the evidence needed to prove it. The more cogent the evidence must be in order to prove it. What that means, though, is arbitral. What it means is different standards of proof, different laws. Arbitral tribunals need not wait for completion and should not wait for the completion of criminal proceedings to act. Now, this isn't to say that the consequences of such proceedings cannot be of significance, but in general, they're significant as part of the factual matrix. Admissions made by a party in criminal proceedings, for example, in a deferred prosecution agreement, could be highly relevant, as too could convictions and decisions not to prosecute. To take one example, in EDF services and Romania, which was an ICSID arbitration brought under the Romania UK BIT, the applicant argued that its refusal to comply with a demand for a bribe by senior governmental officials led to a concerted attack on its business in Romania, which resulted in the total loss of its operations in that country. Now, dismissing the claim on the basis that the applicant had failed to prove its case, the tribunal placed weight on the fact that the Romanian anti-corruption authority, the DNA, had twice investigated and twice rejected the claim, which conclusions had been twice reviewed and affirmed by the Romanian criminal court. So national decisions can be of probative value, but it's not to say that arbitral tribunals need wait till they're issued before making their own determinations. I move on to look at allegations of illegal conduct by parties during the arbitral process. How should arbitrators respond to allegations that a party to arbitral proceedings has acted illegally, even criminally, in prosecuting or defending the arbitration? Now, an obvious example already mentioned, it would be when one party alleges another has illegally obtained evidence, and in addition to bringing the matter to the tribunal's notice, makes a criminal complaint to the relevant national authorities. So it might be argued that one party obtained evidence through hacking the other party's computer network or its employees' mobile phones. And it can generally, I think, be assumed that evidence obtained by hacking has been obtained illegally. I don't think that's particularly controversial. Another way, of course, would be simply to bribe an employee of the other party to provide confidential information, conduct which can be assumed to be criminal. Or a more old school complaint would be that agents of one party trespassed on the property of the other party and went through its trash. We discarded documents, which they then took away. This famously was the modus operandi of Benji the bin man Pell, who went through the rubbish of London law firms looking for tidbits about their famous clients, which he then sold to the tabloid press. It's a nice question whether it's criminal or not, but whether such conduct is criminal or illegal can be a nice issue. But if evidence is illegally obtained, the important question is, what should the consequences be for the party seeking to rely on it? Now, I don't think international law actually says very much about this. Yeah, on the margins, yes, evidence obtained in really iniquitous ways is probably not admissible. If you torture people, things like that. But apart from that, I'm not sure international law says very much. National legal systems vary really quite widely. And issues can again arise as to what national law the tribunal should apply. The seat of the arbitration might be in one country, the hacking takes place against computers located in another, by hackers in the territory of a third, etc. Moreover, if you look at the various arbitration rules, I think the most you can say is they lack specificity. They generally give arbitrators the power to determine the admissibility and weight of evidence presented by the parties, but with the exception of the IBA rules on the taking of evidence in international arbitration, which unless expressly adopted in an arbitration are really only guidelines, they don't say what principles they should apply when doing so. I won't go through various rules. Further question arises, was the party seeking to rely on the evidence complicit in the iniquity? Or was it, for example, the act of some whistleblower within the other party's organization? We actually now have a line of cases in national and international courts about whether you can rely on WikiLeaks documents in litigation. And by and large, the answer is yes, because they're out there. It'd be ridiculous. You're not involved in, you didn't get them. They're out there. It'd be ridiculous not to allow parties to do so. But, you can think about, we're seeing this all the time, aren't we? Paradise Papers, Panama Papers, LuxLeaks, I should mention as well. So, on whom's the burden of proof? What's the standard of proof when such allegations are made? Is the evidence inadmissible for some other reason? For example, is it confidential or protected by legal professional privilege, so the party could not have been required to disclose it, with possible penalty of adverse inferences being drawn had it failed to do so? Now, in the NAFTA arbitration, Methanex and United States of America, the applicant, through a law firm, obtained evidence that it put before the tribunal through trespassing on the property of the head of a lobbying organization. It's quite old school, this is quite an old case, and searching through internal trash cans and dumpsters. Right. Now, the tribunal upheld the USA's challenge to the admissibility of the documents and ordered that they would form no part of the evidential record of the arbitral proceedings. And I quote, "In the tribunal's view, the disputing parties each owed in this arbitration a general legal duty to the other and to the tribunal to conduct themselves in good faith during these arbitration proceedings and to respect the equality of arms between them the principles of equal treatment and procedural fairness also being required by Article 15.1 of the UNCITRAL rules. As a general principle, therefore, just as it would be wrong, and this is quite interesting, just as it would be wrong for the US, ex hypothese, just a random hypothesis, to misuse its intelligence assets to spy on Methanex, its witnesses, and to introduce into evidence the resulting materials into this arbitration. So it would be wrong for Methanex to introduce evidential materials obtained by Methanex unlawfully. Now, the tribunal saw three issues as relevant: legality, materiality, and exercise of the tribunal's discretion. As regards legality, the tribunal found the evidence showed beyond any reasonable doubt, criminal standard there, interestingly, that Methanex unlawfully committed multiple acts of trespass over many months in surreptitiously procuring the documents. Moreover, the tribunal considered that the documents had only marginal evidential significance. And finally, the tribunal placed considerable emphasis on the parties' obligation to arbitrate in good faith, concluding that it would be wrong to allow Methanex to introduce this documentation into these proceedings in violation of a general duty of good faith imposed by the UNCITRAL rules, and indeed incumbent on all who participate in international arbitration, without which it cannot operate. Now, it can be seen the existence of any criminal proceedings against Methanex and or its agents only went to the first of those three issues. Now, the Methanex tribunal is also interesting on the burden and standard of proof to be applied to such allegations. Once the USA demonstrated prima facie that the evidence had been secured unlawfully, the burden of proof with respect to its admissibility shifted to Methanex, though Methanex, however, did not call evidence on the matter. I'll mention another investment treaty arbitration, Libananco Holdings in Turkey. Good one, this one. There is the respondent, not the claimant, sought to rely on documents that had been obtained in a questionable manner. The respondent was Turkey, and the respondent, having obtained more than 2,000 privileged and or confidential emails obtained between the claimant and its lawyers, sought to use them in evidence in the arbitration. I always think this is very bold indeed, very bold indeed. And the tribunal weighed the importance of confidentiality and legal privilege and the obligation on all parties to arbitrate fairly and in good faith, and ordered destruction and exclusion from evidence of all privilege and confidential communication. Now, indeed, this case, I think, argues against too great a reliance on the existence of criminal proceedings. The documents, why? Because the documents had been obtained through court-ordered intercepts. It's a great thing about being a state. The respondent state claimed that the surveillance had been directed at the investigation of certain money laundering activities unrelated to the arbitration proceedings. And the Libananco case moves us to our final issue because it raises the question of how an arbitral tribunal can prevent its processes being subverted by a state party's manipulation of the criminal process. Libananco is a very good example of that. So what about situations where you have allegations that the state party to an arbitration is misusing its criminal processes to hinder the other party from pursuing the arbitration? Now, such allegations have been made public in a number of investment treaty arbitrations in recent years. I'll just address a few conducted under the auspices of ICSID, the International Centre for the Settlement of Investment Disputes. Claimants have stated that their officers and employees have been called witnesses in criminal investigations, made subject to such proceedings, been prosecuted, had extradition proceedings brought against, and even put in pre-trial detention. Now, I'm always a bit skeptical. I always think there's a degree of pearl clutching from claimants in these cases, but it's all very factual specific. But under the guise of criminal proceedings, we've also seen state authorities have seized claimants' documents as well. Now, in all cases, what has been argued is that such activities were not good faith efforts to discover and combat criminality. This takes us back, of course, to corruption allegations in particular. It's quite common to have a situation where a claim is brought against the state, and the state defends the claim by saying, well, the investment is tainted by corruption. In all cases, it's been argued that such activities were not good faith efforts to discover and combat criminality, but they were aimed at hindering claimants' ability to effectively prosecute their case in the arbitration. In particular, by preventing them from putting their witnesses and their evidence before the tribunal. What's interesting is how tribunals themselves have responded to these allegations. Such activities have formed the basis, in particular, of requests for provisional measures. If you look at Article 47 of the ICSID Convention, it provides that tribunals may, if they consider that the circumstances so require, recommend, interesting term, of course, recommend any provisional measures that should be taken to preserve the rights of either parties. Under Rule 39 of the ICSID arbitration rules, a party may request a tribunal to recommend provisional measures for the preservation of their rights. Now, on their face, I mentioned it says recommend. Such provisions recommend, argue for the non-binding nature of provisional measures. Now, those of you who read the newspapers in this country may well be aware it's not just ICSID tribunals that it's controversial provisional measures. There's been an issue concerning the binding nature, or maybe not the binding nature, of provisional measures ordered by the European Court of Human Rights in recent years. We won't go there, but I mention this solely to remind you that arbitration is not a self-contained regime. Just knowing about arbitration is not always very helpful. But so you might say the terms of the provisions argue for the non-binding nature of provisional measures. Behind them, however, is the fact that ICSID is a body established by treaty. It administers a largely self-contained regime, which is not subject, and this is the whole point of it, not subject to national court supervision. Contracting parties' obligations under the ICSID Convention are obligations under international law, which they cannot plead their national law to avoid, unless you're the EU, but we're not going to go there at the moment. So it's unsurprising, perhaps, that ICSID tribunals have been willing to be rather bolder than tribunals established under other sets of arbitral rules, even though those rules may make similar provision for the indication of provisional measures. Now, tribunals do seem agreed that indicating provisional measures in such circumstances should be exceptional. If you go back to cases like the Churchill mining in Indonesia, the tribunal there says the right, even the duty to conduct criminal investigations and prosecutions is a prerogative of any sovereign state. The tribunal in Quaiborax and Bolivia says the international protection granted to investors does not exempt suspected criminals from prosecution by virtue of them being investors. Tribunal in Tenerife and Argentina repeats, it will usually require exceptional circumstances to justify the granting of provisional measures to suspend criminal proceedings by a state. Yet it does seem that ICSID tribunals have been readier to find such circumstances. And I'll just give a couple of examples. Hydro and others in Albania. It's an arbitration brought under the Albania-Italy BIT. The tribunal made an order for provisional measures recommending the suspension of criminal and extradition proceedings against two individuals, Mr. Bichetti and a Mr. De Renzis. On a side note, for those of you who are interested in football, Mr. Bichetti was at the time, I'm not sure whether he still was, but he was at the time president of the London Football Club, Leyton Orient. Right? Perhaps not the most distinguished London football club, but nonetheless, I find it interesting. Now, Mr. Bichetti and Mr. De Renzis had ownership interests in the corporate claimants in the case, as well as being parties on their own behalf. The criminal proceedings brought against them by the Albanian authorities related directly to the subject matter of the arbitration. And the claimants argued that the respondent state had sought to undermine their investments in Albania, including by bringing tax audit proceedings and money laundering investigations against the claimants and Albanian entities owned by them, and by instituting criminal proceedings against Mr. Bichetti and Mr. De Renzis. Now, the tribunal considered that Mr. Bichetti and Mr. De Renzis' possible incarceration in Albania, if extradited from the UK, which is where they were, would prevent them from effectively managing their business and fully participating in the arbitration, which threatened the procedural integrity of the proceedings. As an aside, as anyone who knows who practices in criminal law, people are regularly locked up, right, prior to being convicted. And we generally don't think it's problematic. Well, we might think it's problematic. You do, bail is the presumption is you get bail, but there are lots of reasons why you might not. But it's not generally seen as inimical to your right to a fair trial that you don't get bail. Maybe it's different in arbitration. I don't know. But what the tribunal said was, while the destruction of the claimant's investments in Albania might be repaired by an award of damages, that was not the case as regards the claimant's ability effectively to participate in the arbitration, which is what it said was at stake with regard to their extradition and subsequent possible incarceration in Albania pre-trial. Now, the tribunal therefore recommended that the criminal proceedings against them be stayed until the conclusion of the arbitration, which indeed, to be fair, resulted in an award of damages to the claimant. Now, interestingly, Mrs. Bichetti and De Renzis were then able to use the provisional measures order in the English courts to have their extradition proceedings stayed on the basis of abusive process. It should be noted, however, the decision was one of first instance, district judge, and moreover, that the government of Albania, possibly unwisely, accepted it was bound by the tribunal's decision. The provisional measures order in Nova Group Investments and Romania had a rather different reception in the English courts, and I'll just turn to that briefly. Nova Group Investments, the tribunal recommended, subject to various conditions, that Romania withdraw its request for the extradition of a Mr. Alexander Adamescu from the UK, but didn't ask Romania to stay criminal proceedings against him. Now, Alexander Adamescu is the son of Dan Adamescu, who was the founder and chairman of Nova, who had died, and this may have some relevance to this decision, I feel, who died in 2017 while in prison in Romania. But Alexander Adamescu was Nova's sole director, and he was the main witness, I think, in the arbitration proceedings. So he was crucial to Nova's presentation of its case in the arbitration, and his incarceration would prevent him from being able to do so. So the tribunal makes an order. Despite the tribunal's order, however, Romania continued with its extradition request. Before the English courts, at first instance, the judge refused to stay the extradition proceedings pending the conclusion of the arbitration on the ground that to proceed would be an abusive process. Mr. Adamescu sought permission to appeal against the district judge's ruling, but was unsuccessful, on the basis that the provisional measures order prevented Romania from proceeding, although I have to say, he was successful on other grounds. So in the High Court, this is just Whipple stressed that the appellant was not a party to the arbitration. Remember, it's between Nova and Romania, and neither was the UK, following the respondent's argument that the PMO, the Provisional Measures Orders, at its highest, could only bind the parties to the arbitration, nor could the order oust an extradition request pursued under a well-established machinery with origins in EU law implemented by the 2003, I think, Extradition Act. So what can we derive from these cases? Now, first, tribunals have sought to intervene in domestic criminal proceedings when they consider that they have served to prevent parties effectively participating in arbitral proceedings, to require that both parties arbitrate in good faith, and to ensure the integrity of their own proceedings. Second, such orders can only be hortatory. We'll ignore whether they're binding or not, but not least because tribunals have no enforcement powers. You're going to have to rely on the national court. At best, they serve a signaling function that the tribunal considers the targeted criminal proceedings improperly motivated. And it's noticeable that in the Adamescu extradition proceedings, the English courts were more receptive to arguments based on Mr. Adamescu's human rights, which I think must be right. Third, one might think it's somewhat dispiriting how that tribunals have thought it necessary to make such orders. In Adamescu, of course, it's against an EU member state, and the UK, of course, is no longer an EU member state, but there we are. I think that probably concludes what I'm going to say, you might be glad to know. So I've got one final and general point, which is simply this. Arbitral tribunals must take account of concurrent criminal proceedings, but they cannot defer entirely to them. That's not only because they are undertaking a different role, but also, unfortunately, because national authorities cannot entirely be trusted. But this in turn means that tribunals can find themselves in a very difficult situation. They can find themselves between Scylla and Charybdis, so that arbitrators must be skillful navigators to get safely to their destination, which is, of course, an enforceable award. Thank you.